ಕೂಡ Urban Development Authorities.
ಜ್ಯೂಸು ಮಾತ್ರೆ ಎಲ್ಲ ಬೇಕು.
So now, if you go into the
How do I change my name?
coming to
one matter for arbitration matter 2017, 2-3 times. Arbitration. This is 2-3 times, my lord, heard. Ultimately, my lord, last time recused and by the, because my lord. Yes, my lord. No date has been fixed. Next week, please. Date may be given, madam.
2310, sir.
Much of.
One judgment wrote that yesterday, but I'll include your finishing. You have given the other side also? Yes, sir, I will furnish the copy. I will furnish the copy. Yes, sir, I will furnish the copy. Yes, but yes.
Page was for adjournments. Page number 5, 22. Page number.
Serial number 19, my lords, on page number 5. The
15
response counsel, my lords, there's an unexpected death in the family. 19, serial number 19. There's an unexpected death in the council's family. So any date next week or any other date for the respondent.
Yeah.
I've already furnished the call. I've already told him, and it's mentioned.
Okay, sir. 2611.
Yes.
My lords, may I mention seal number 21, my lords? My lords, I appear for the appellant. My lords, I'm led by senior counsel in this matter with some difficulty today. May this be kept any date next week, my lords?
We do not return it. See.
My lords.
Okay, let's see, if we are hearing any other matter that will consume the day, we will return.
Yes.
Okay?
My lord,
Yes.
your
Yes,
lords, kind from, my lord,
We
serial
do
number
not-
29, my lords, I've informed the opposite side. My lords, I need a week's time.
What is the difficulty?
My lords,
You are for whom?
I am for the appellant, my lords.
Yes.
Please, my lord, there are certain technical words which I use in the judgment, which needs a little more of reading is what my senior. Please, my lords. Please, my lords, a week after next, my lords, we have
We'll see.
informed.
Yes.
My lords, the opposite advocate has been informed, he's not available from 28th to 30th as well.
We'll see for the day. Let's see how the board goes. Okay?
28,
My lords.
8 serial number. This is a commercial matter, my lord, commercial suit. As I request for us 2 weeks' time to explore the possibility of any settlement, my lord.
We'll the other side.
That's it, my lord.
We will just wait.
Please.
Serial number 26, my lord. Matter is the arbitration suit. My lord, the first appellant is dead. I have to make an application to bring appellant. There are 3 appellants, my lord.
Bring the agas on. That's right.
Please, grateful.
1311.
My lord, serial number 27, my lord. I'm for the respondent and the
I'm for the appellant in the matter.
applicant is present, my lord. There is a small inconvenience. My colleague is out of station. My colleague is out of station, my lords. Respondent.
I appear for the appellant. I have no objection. Even we have
My
some
lords,
inconvenience today, your lordship, any day. Oblige.
My lord, serial number 25, my lords. Serial number 25.
Okay. My senior is not keeping well from last 3 days. Kindly have it after 1 week minutes. Serial number 25. Appellant minutes, sorry. I'm for the appellant. Serial number 25. Kindly have it after 1 week minutes. Because my senior is not keeping well from last 3 days minutes. And one submission minute. There is a name Mr. K. Hemakumar. K. Hemakumar is now additional government advocate. Kindly delete that name and I'll give a name. Yeah, we have Wakalat.
No, I mean other.
Surendran Tambu Chetty.
Item number 23, if I am permitted.
20th November, sir, 20th November.
Item number 23, I am for the contesting respondents. Matter is regarding the allotment of civic community site. My lords directed me to submit the synopsis also, could not be, any date may be.
Yes.
I have, yes. We'll do.
I have filed by counter, my lord, after service. Appellants, well, appellants.
Petitioner.
Petitioners, yes.
The learned friend is the petitioner.
Yes, Mr. Shishant. My lord, I have, my submission is, we have filed the, in the second matter, I said I want to file my SO. Your lordship has granted it. That's the audit sheet. I have filed the SO after service on the other side, and it's a part of the record now. My lord, I have complied with it so far as I am concerned, my lord, though there is some delay, yes. But so far as others are concerned, as your lordship.
Anything, my lord, left
1 minute, 1 minute. Yes, ma'am. I am ready, my lord. I appear for the petition. Yes. Yes, my lord. The BDA has filed and the state was. Yes, my lord. Yes, my lord, that I have seen the order sheet, your lordship. Second case,
The next matter, second matter, was because the learned.
No, 1 minute.
Has been tagged on. There, my lord, the second set, etc., have to be filed.
One has sought time of the last.
Yes.
File counter.
Please.
Yes.
Sir, BBM,
Number 5 and 3.
Devendra Prasad. For R5.
Yes. For in the first case, I appear for the petitioners, my lord. I have nothing to file there. In the second case, I appear for some of the respondents. Yes, my lord, I have filed my counter. On after service, pursuant to the directions of this court. Second case, I think. No. Yes, my lord. Yes, my lord. Yes, my lord. But yes, my lord. Please, your lordship.
Serial number 24. It's for final hearing and for the appellant. I seek for a short accommodation, my lord. My senior is he's having some inconvenience today. Any day, a date may be fixed, my lord. I'll address. In fact, we were trying to move the matter before the much.
Serial number 1.
Sorry, my lord, please, my lord, first time it had come, I will cure, my lord. I will, my lord, first time. Second, 1 to 3, my lord, I will cure everything because all are connected.
And 14 also, in fact.
14 also, my lord.
All arise from a common order.
Next date, my lord, we will get ready for argument also. I will.
My senior is there online.
My lords,
My senior is there online. Yes.
My lords, am I audible, my lords? My lords, I'm appearing in the matter. All the four of them, my lords.
Yes.
It arises out of a common order which has been passed by the FEMA Tribunal. My lord, this was filed in 2019, and until date, my lord, there have been various adjournments that have been taken by the state on one ground or the other. Now, my lords, finally, there is just one objection which I understand, which is left in serial number 1, which is that, my lords, the person unfortunately has passed away, and there is my lords, heir who has to be brought on record. But otherwise, my lords, this matter is against an order of stay by the tribunal, FEMA Tribunal. The final hearing in the FEMA Tribunal was listed. It has been listed couple of times. It's gotten adjourned, but sometime in November, end of November or December, the matter is going to be heard finally by the appellate tribunal. So my request would be, Manoj, that this matter can be disposed of. There's nothing in the matter because they are seeking stay of an order of stay, which, Manoj, on the face of it, if your lordship were to see the order,
But the tribunal, because of the pendency of these petitions or appeals, is not saying that they will not hear the matter.
No, Manoj. In fact, the appellant here has been telling the tribunal that, Manoj, the matter is pending before your lordships. And before your lordships, Manoj, we are told that the matter is pending. The final matter for hearing is pending in the tribunal. So, Manoj, either ways, the one matter has to be disposed of, and therefore my request would be this.
2 weeks time, I will cure everything and I will get ready, because I am the panel advocate earlier, my lord. I am the next I have appeared. So I will do everything, my lord. I will not ask for. Finally, my lord.
We will say as a last opportunity.
Please, ma'am, please.
As a last opportunity, we will give you 4 weeks.
Please.
Have it after 4 weeks.
I will not ask, my lord, on that day.
As a last opportunity, 4 weeks are granted to remove office objection. This would be separate orders in 1 to 3, but common.
2111, sir.
Okay. And in
Plus,
14, just read 14, re-notify on 14.
Much,
Please.
much obliged. Much.
Please.
Grateful.
So 14 November. All please. Much. Next 4.
Serial number 4. JM Party. Serial number 4.
Appellant, my lord, in this matter, my lord, the respondent number 3 has been served in 4.2.
Who appears for respondent number 2? 3.
Respondent number 3, my lord, it is served, but none appears.
In 4.2, respondent number 3 has been served.
So, yes, my lord.
But
The
what about
appeals
that
are arising out of the same order, my lord,
common order?
common order.
There is, just say this, there is no appearance for, you appear for whom?
My lords, the Joint Commissioner.
Joint Commissioner. He is the only sole official respondent.
Lords, 1 and 2
1 and 2.
are government respondents. The regional transport officer.
Though the respondents are, okay, though respondents 1 and 2, these are 1 and 2 are common in all the appeals?
My lords. Yes, my lords. 1 and 2 are common in 4.1 and
The
4.1.
The unofficial, we just say that the other respondents are not represented today. We have been informed by the counsel appearing for the appellant bank, that the respondent number 3 has been served in WA 1447 of 2018. That's right. 4.2 said, no?
4.2.
Or 4.3 or 4.2?
4.2.
2.
4.2.
1447 of 2018. And as such, the service on the said respondents in the other appeals be treated as effected, as there is no presence for respondent number 3. In these appeals, in the interest of justice, we re-notify the matter on. Re-notify these appeals on. Just give it. I don't know, there is a use. What R3? No? The R3 appeal, see 4.2. Everything will be substituted. He's only for the substituted service. We will not say so. The learner counsel for the appellant to inform the counsel for the respondent number 3.
My lord, he remained absent in the writ petition also, my lord.
We
Respondent
remain-
number 3, yes, my lord.
Served and
Served and remained absent.
Oh, no, acha, R3, this is the gentleman. Okay. He has not filed wakalat also. Okay, very well. That's right. See, you filed for substituted service. In the other 2 appeals. In
Lord,
4.1
since he
and
was
4.
the common appeals, all the appeals is the common respondent. That is the reason I filed in one appeal.
Right, but once he has been served, he is not appearing. What is
Yes.
the use of? If you want to take a chance, you
No, my lord, I'll not press that application.
won't press those
I'll not
applications. We don't know what is the effect there. If you are not serving. And who was to deposit 50% of the demand made?
It is our entire amount has been deposited before the joint commissioner, my lord.
Very well. Shall we record your statement on, you want to withdraw the substituted service? What do you say?
Lord, I'm in little dilemma. I'll decide on that, my lord.
Sir, very well. We'll give a date. Let's see if he comes. The learner counsel for the appellant further states that the respondent number 3 was not appearing before the writ court as well. She also states that she shall take instructions whether to withdraw the applications filed in 1448/2018 and 1446/2018 for substituted service in respect of respondent number 3 on the next date of hearing.
Please, obliged.
1311. Serial number 5.
Lord, 5, my lord, I appear for the appellant. Respondent 1 and 2 are not served, my lord. I will take fresh steps, my lord.
Let fresh notice be issued for service on respondent number 1 and 2. Returnable on.
1012. Serial number 6.
Let
Vivek Pula.
fresh notice be issued to
No,
the
Lord,
respondent.
the dispute out of which the present appeal arises, Lord, has been settled between the parties. It is no longer interested.
So you want to withdraw this?
Yes.
Mr. Hola, okay. Just say that Mr. Hola has filed and Mr. Hola, the advocate for the appellant, has filed a memo
Rajendra and Ms.
which is taken on record, and the same reads as under. In view of the contents of the memo, the appeal is dismissed as withdrawn. Just say that Mr. Hola reiterates the prayer as made in the memo. So in view of the memo and also the submission made by Mr. Hola, the appeal is dismissed as withdrawn.
Okay.
Just check the IS.
7. Srimati Kavita.
7 I appear for 7.1 and 7 Your Worship. On 8/7/2022, I have already complied with the process, Your Worship.
When did you do that?
8/7/2022.
That's long back, man. When was the matter listed last?
The matter was listed on 29/7/2022, Your Worship. It was adjourned on that particular day.
Oh, yes, this is the report. Respondent unserved, address 1 left without instruction, 2 also same.
I'll take fresh steps.
In terms of the notice issued on 18/7/2022, the report of the registry suggests that the respondent has left without instruction. Respondent has left from both the addresses, that is address number 1 and 2, without on her furnishing the fresh address.
I'll furnish a
We
fresh.
just make an attempt, fresh address, notice be issued to the respondents, noting the said submission on the appellant furnishing the fresh address. Let notice be issued to the respondent returnable on.
1612.
This would be for the second also, in both the appeals, just say in both the appeals.
Serial number 8, Shri Suresh Reddy. Serial number 8.
My lord, I am for appellant, my lord. I'll undertake to file power, my lord, on behalf of appellants.
Oh, you have now come?
Now, yes, my lord.
Mr. Reddy is not appearing.
No, my lord, he is not appearing. MO has to be accepted.
Pardon, you appear for whom? The
Appellant, my lord, all the appellants.
So-and-so appears, so-and-so advocate appears, states that henceforth he shall appear for the appellant and shall file wakalat within 1 week.
Yes, my lord.
Within 1 week, noting the said submission, comma, if wakalat is filed by Mr. Raghunath, comma,
Ravindranath. Ravindranath.
Mr. Ravindranath, his name shall be shown in the cause list by deleting the name of Mr. Suresh Reddy.
Yes.
Just to re-notify the appeal on
511.
Obliged.
Serial number 9, Shri Vikar Ahmad. 9.
If the appellant in the matter, my lord. I'll take steps for the issuance of notice to the respondent, my lord, the sole respondent in the matter.
See, there is a notice on IA for the first time. What is the IA about?
Dispensation, my lord.
Why we only know, but have you served on the appeal?
No, my lord, the notice needs to be served on the appeal itself, my lord.
Let's see when was the notice issued.
31/8/23.
This is item 9 number.
23.
The respondent is still unserved. Let fresh notice be issued for service on the respondent returnable on.
I'll take fresh notice, my lord.
1112. Serial number 10, Shri Deshpande.
My lord,
I appear for the appellant, my lord, that there has been a change in the panel, my lord. The name of Mr. Akash Shetty may kindly be shown. Department has reconstituted the panel. So.
Pardon?
The department has reconstituted the panel.
Yes.
And one Mr. Akash Shetty has been allotted with this case. I have been communicated with this communication by the department. It may be had after 2 weeks, my lord. Akash Shetty has been re-nominated for representing this appeal.
Instead of Mr. Amit Anand Deshpande.
Exactly, my lord. There has been a reconstitution of the panel.
Akash Shetty.
See, he was to take steps for amended cost item.
Yes, my lord, the amended cost title, I have informed them, my lord, he shall file it. I have informed him. We have carried out the amendment, my lord, only the copy is to be filed. I shall inform him.
Mr. Mr. So-and-so appears for Mr. Akash Shetty, states that henceforth Mr. Akash Shetty shall appear for the appellants and shall file wakalat in that regard. Full stop. If such a if wakalat is filed, the name of Mr. Akash Shetty shall be shown in the cause list by deleting the name of Mr. Amit Anand Deshpande. Stop, re-notify.
2511.
Grateful, my lord.
My lords, can it be just 1 week after that? Let's see if it's not incorrect. Can it be after 1 week after 25th?
212. 212.
Obliged. Obliged.
For this tax matters.
Obliged.
Monday. Oh, you have given which date, no?
25. He wants next.
Where is the calendar here? Just ask him to put the calendar. No, let them give. You said two?
He wants next week.
What's up? Yes.
Serial number 11. 11, Shri Surana.
So you serve the
Take
other
step,
side.
fresh.
Let fresh notice be issued for service on respondent number 1 and 2. Returnable on
312.
where is the last order of notice?
Sir, left, sir, last time notice.
These are not uploaded. So you have to see, maybe you have to furnish a fresh address. Just say this on the appellant furnishing fresh address of the respondent number 1 and 2. Notice shall be issued to the said respondents. To stop this, we say so as per the report of the registry, this we say so as the registry's reports states addressee left.
312, sir. Serial number 12, Sri Gautam.
Milords, I appear for the appellants, Milords. Milords, a week's time to ensure service on the respondents, Milords. I seek a week's accommodation to ensure the service on the respondent.
Let fresh notice be issued to the respondent returnable on. Is there any report on this?
Yes, sir.
Same order, ma'am. Left, ma'am. Same order. As the report suggests, left.
412, serial number 13.
Yes, my lord, for serial number 13, I'm appearing for the respondent number 1 and 2 in appeal number 742.
Yes.
Yes, my lord, this appeal is pending. I succeed before the writ court, and the writ court given an opportunity to the respondent number 4 and 5 to amend the notification. They have already amended the notification. This appeal they are dragging on. I don't know why this appeal is pending. This was heard many times. I appeared yesterday. I got the communication late night. That's why I'm appearing.
But serial number 13, Mr. Jeevan Ilargi has requested a week's time.
But you have heard, you are appearing for whom?
Respondent, man.
So where is the Mr. Reddy?
Mr. Jeevan Ilargi.
Where is he?
Is that to come? He requested me over phone that.
Just call him, please.
Pass it over, I inform
Pass me,
please.
so.
Please.
This is, my lord, the GST matter. It is resolved. In fact, the government has already accepted.
We have. What is the name of the council? We have called the council. Let him come.
Please.
Yes.
Mr. Mittal, we have called the council. Let him come.
Grateful, my lord. I'm so sorry.
Sorry, serial number 14, my lord. I know my lord, we're pleased to adjourn it in the morning to 21st November. May I request for 25th instead, my lord? This.
Where is the council?
I will inform. Mr. Jaikar Shetty, I'll inform.
Call him.
I'll call him. Please. I'll
So
do.
that everything is settled before him.
Please. I'll do.
15, Swapna Nayak.
I am for the response in this case, my lord.
Yes. What happened? 7-8 order. What does it say? Dismiss.
It was dismissed. Sufficient opportunity has been given to the appellant.
You are for the
I am
respondent.
for the respondent.
Let's see pass over.
Much of it.
Council comes.
16, Sri Mahant. Fresh.
Hearing for respondent number 1.
You're ready for arguments?
Your Honor, if the same may be passed over.
Short date, the reason is this, my lord.
Lord, if it may be passed over, my lord, senior.
Minute, please. Let's hear. Yes.
I'm seeking a short accommodation. This is the case, my lord, where this honorable court was pleased to grant an absolute stay of the arbitral award. And we were asked to deposit 75% of the award amount, and now have deposited. And now question is, we also, in fact, I personally went to their senior's office and discussed with him, if there is any chance of any settlement. We tentatively agreed for 30 lakhs. The award amount was 25 lakhs, together with interest 12%. In fact, we will interact with him within 2 days, we'll come back. I personally went.
Are there any talks? Did you get in touch with them?
No?
This was before, when the matter was listed, your lordships, it was talks went on. After that, there's no talks.
let my learned friend come to the, let my learned friend speak to the senior. It may be called on Monday or what.
But I have no objection.
At the
Monday or
request of-
Tuesday may be kindly picked.
Shall we record? You want to settle it?
Not necessary.
Very well. At the request of counsel for the appellant, re-notify and just give Tuesday, Wednesday or next week. Anything.
23:10, sir.
Grateful.
Here also. Ma'am.
Sorry, my lord.
Yes. So what is the date given?
23:10, sir.
Okay. Next.
17.
My lord, serial number 17.
And for the respondent,
Yes.
my lord.
My lord, I appear for the appellant. This matter has been reassigned by Mr. Amit Deshpande to me very recently. I'm in the yet to collect the file, my lord. Lordship may grant me 2 weeks' time. In the meantime, I'll comply with the office objection of amending the cost title and filing the amended cost title also, my lord.
Who appears for the respondent? Yes.
Bala Subramanian.
Yeah, I am for the respondent, my lord. A short date may be given for hearing, my lord. It's
Yes,
pending
yes,
since
yes, counsel for
2021.
the- Now you shall appear.
I shall appear. I have filed my memo for appearance, my lord. Arvind Chavan.
Oh, your name is already depicted, Mr.
Yes,
Chauhan.
I have just recently filed it, but 10 days back, my lord, before vacation. The file was not
Huge time.
The file was not received. I'm collecting it from the department. That's all, my lord.
Yes.
Apologies for.
At the request of Mr. Chauhan to retrieve the file from the department, re-notify.
Please, my lord.
Short
11th
date is
of
requested.
November.
Please.
Sir,
Next.
11th of November, sir. Serial number 18, Sri Rajesh.
Pass over.
19 urgent, 20, Sri Ravindra,
Pass over.
21, Sri Pradyumna Narasimha.
Pass over.
I appear for the appellant.
My lords, we just wanted a short accommodation, my lords, to sometime next week. I'm led by senior counsel, my lords. It's a short matter. It's a 37 petition.
That's more reason you should argue.
My lords,
To argue, we'll pass over. Look into the matter.
please, my lords.
Next.
22, serial number 22,
For the
government certificate.
I appear for the petition. Responded to this.
You are ready?
Lord, there is a delay of 189 days. 189 days delay, my lord. Your lordship kindly see the affidavit. They are simply mentioning the table-wise table dates, my lord, without any reasons.
From which table the file went, huh?
I'll go to you.
We will see. Pass over. Pass over, pass over.
23. 23.
Yes, come.
No, I had submitted the.
Thing. You have filed you are for the petitioner?
Yes, I have for the petitioner in WP number 51531.
Or you are in the 51531?
And
Now tell us one.
I am the petitioner in 11325 PIL petition.
You are petitioner in 11325 or 51531?
11325, I am the petitioner.
Very well. You have filed your counter
Yes, my
to
lord. I
their
have filed-
petition to petition number 2. Petition number 2.
Yes, I have served, my lord.
Who appears for petitioners in 51531?
Suhas.
He had.
When did you file it, ma'am? Is counter on record? 23.
No, sir. Settlement.
He says, when did you file your counter?
It is on 1410, it seems, my lord.
1410 is
1410.
day before.
Yes, my lord.
You say this counter affidavit stated to have been filed by the respondents.
Number 4, my lord. I am respondent number 4 in
Please give
51531.
us the file.
4, 7, 9 and 10. 4 to 7, 9 and 10.
Who appears for BDA? Mr. Charadi, you have not filed your counter.
Public interest litigation, we have filed our counter.
We don't know because on the last day, it will tell you. You appear for BBMP.
No, BDA.
BD. Who appears for BBMP? Respondent number 3 and 5.
Devendrappa appears for BBMP.
Pardon?
Mr. Devendrappa appears for BBMP. Mr. Devendrappa clearly stating that they don't have any documents to show that this land was handed over to them as a park. This is the statement of the PDA which is on record.
But tell me, who appears for the petitioner in 515, the second matter?
Mr. Shishidhar, the learned senior counsel was appearing. He informed me in the morning that he has some difficulty. Shishidhar, he has informed me that some difficulty for him today.
Just say this, Mr. Sheshadri, learned senior counsel appearing for the petitioners in WP 11325 and also for some of the also for the respondents.
4 to 7, 9 and 10. My lord.
4 to 11.
4 to 7, 9 and 10.
Very good. Because last order records 4 to 11. 4 to 11 in writ petition number 51531/2019 states that the counter affidavit has been filed by the said respondents in 51531/2019.
Your Lordship.
The same is not on record. The registry to get the same placed on record.
It's placed on record.
Just
They
get
have
it
noted.
placed on record. It is not there on record. The counsel for the petitioner in 51531/2019 shall be at liberty to file rejoinder to the counter rejoinder. Say that very well. Rejoinder to the counter affidavit filed by respondents 4 to 11, 1 week before the next date of hearing. Okay, now who is the counsel for BBMP? Has Mr. Sheshadri, BBMP has filed any counter or objections?
No, my lord, in this form, the second one, they are the actually contesting respondents because
That's
they
why
have
we
declared.
recollect.
They are the they have declared it as a park.
Have they filed it in the first one?
Yes, I think. My lord,
Just check up that. If that
I have, my lord.
if that be so, that should be the stand in the second one also.
In the petition, Manoj, and the petitioner in 23.1.
Yes.
I'm for the
In first case, it has been filed. BDA has filed. It's
BBMP.
BBMP has not filed.
Because last time they filed it.
Yeah.
Who appears for BBMP?
Manoj, I appear for the petitioner in 23.1.
Yes, 23.1, we have given you time to file rejoinder to what has been filed by respondent 4 to 11.
Manoj, also the translations are ready, Manoj. They will be filed today itself.
Yeah, you file your translation then.
Please, please.
Who will file the translations? Who will file the translations?
Manoj, we are filing the translations in 23.1.
Now, Mr. Sheshadri, this need to be worked out. If there are any translations in the
second writ petition, because it was to the learned single day, perhaps the translation is not there. Now I am informed that other council has filed it.
We'll file it.
Say so
It is
wherever
ready.
the required translation need be.
Yes, may I?
Yes.
My lord, subject to, with your lordship's kind leave, my lord, 2 or 3 submissions, my lord, so that the ambit, the scope and the sweep of this writ petition is a very simple writ petition, my lord. I have formulated, according to my understanding, my lord, there's only one issue which arises, though there is a lot of, now I'll read it, my lord, we have cast it to place it before my lord. Only to comprehend, my lord, as to in the writ petition, in public interest is as to whether the area marked as open space / park in a private layout, that is defense except society, sanctioned under section 32 of the BDA Act of so by creating an additional CA site number so modifying the approved plan, diverting to a different purpose, allotting it to a club. I may keep my the court very comfortable. Well, there is have come. My submission is only this. I will not argue on the merits of the matter. Now, what I'm trying to say is material facts are not in dispute. As the foundational facts are not in dispute. The matter is covered by the Honorable Supreme Court not once, umpteen number of times, straight from Mudapa's case, my lord, till now. It is a privilege, my lord, to argue because I have been 78 summers on Cosmos. I have sent all of them as a Bangalorean, my lord. I am interested passionately to defend the park, my lord. The court has gone to the extent, no, they have committed contempt, both all the state and BMP. I don't have to dilate on that. I have to only point out, look at this. This can't be done by the state and its authorities. I am concerned, my lord, at my age, having regard to 53 summers. What I'm concerned is, you can't defy the court orders. And Article 141, 134, it becomes, sonnet written on water. That's not, that's where I'm concerned. I'm anxious, my lord, only to bring petition. There is nothing which is in dispute, factual matters or legal matters. It's a question of perception of what they feel about. That's all. My lord, yes. If I argue, my lord, I mean, just subject to what my lord is going to say, the first of the matter is covered by the second of the matter is covered. So the principal writ petition, the other side and things like that, produced a photograph, taken aerial photograph, where children are playing, old people are sitting, and the house, this so-called park is surrounded by all residential houses, my lord. Consequently, they have not been able to improve. Well, there is a kind of tiff when I go there.
We'll look into it.
So priority is all what I'm trying to impress upon your lordship. Please don't, my only very fervent appeal is kindly give the earliest time, my lord, subject to the convenience of the court.
Who appears for BBMP? Where is your counter? Have you filed your counter? So shall we record it that it will be treated as a counter in the second matter? You have sent it for signature. When are you filing it? We'll give you 2 weeks. Okay. The counsel appearing for BBMP in 313, the other one, states that the counter affidavit has been sent for signature. The same shall be, the petitioner shall be at liberty. Who appears for the petitioner in 515? Yes, you will file rejoinder to that.
Please.
Rejoinder be filed within 2 weeks thereafter.
Please.
Full stop. The counsels appearing for the parties in these two petitions shall ensure the English translation of Kannada documents are filed at least 1 week before the next date of hearing.
Please.
Okay. The English translation of the Kannada documents in their respective pleadings are filed 1 week before the next date of hearing.
Please.
Okay, now just give it after 4 weeks.
Sir, 2111.
Please.
2111.
Grateful.
Okay.
I was trying to assist.
So Sheshadri, you have in the sense that surely you are assisting only the court.
Yes.
As a counsel.
That too in a public
and
interest.
everyone does that.
No, even that too in a public interest litigation.
We'll see.
Please, your lord.
Thank you.
Please.
Next.
24. Serial number 24.
Yes.
Accommodation.
Why?
Senior is having some inconvenience, my lord. Kindly have it on Monday. In fact, we had moved before the earlier roster bench also, my lord, on twice, but the matter was unfortunately not listed.
Who is there? What is
of repetition? But I have one difficulty on reading the orders uploaded on the web. There appears to be no info to the petitioner that there is an interim order. And I order that has not been uploaded, for which my lord, I am handicapped.
I'll kindly have it on Monday, my lord. I'll assist this court.
But what happens is, kindly see the order of
Just
29.
1 minute.
My-
Now, where do you say so there is a no interim order? Which order says the interim order to continue?
My lords. My lords, the first order your lordship may kindly look at is 23/9/2019.
Which order says interim order there? Which order says interim order to continue?
Please, my lord, kindly see 6/11/2019.
Six eleven.
My lords, standard order would be passed that interim order, if any granted earlier. would continue.
Right.
My lords, so there was no, on 23/9, there is no interim order. 6/11 is conditional or any interim order having been granted.
6/11 of
2019 months.
6/11. If add interim or interim leave granted earlier is not of limited duration, the said order will remain unaffected.
It is if there is,
Obviously.
and there is nothing prior to that.
It's all right.
Please, then what happens, my lord, is that kindly see 21/2/2023. Order on IA 2 of 2019. Learned advocate for the appellant submits a stay has already been granted, hence stands disposed of.
It's all right. Whatever stay has been granted, the earlier orders would be seen. And what is the stay about? Stay about a direction that you should go to the appellate forum.
Yes.
That's the direction.
My lords.
He is not going. In any case, he is before us.
My submission is that there is no stay.
See, let's see the order.
My lords.
The order is the impugned order. Hence, the writ petition stand dismissed with liberty to the petitioner to apply if such an appeal is preferred within a few days, the date of receipt copy, the same shall be conserved by the appellate in accordance with the act. That is what stay. He is not going. Effective stay is he will not go. He is before us. We have to decide. Possible the stay effect of the stay order is that 4 weeks which have been granted. If such an appeal is preferred within a period of 4 years from the 4 weeks from the date of receipt, 4 weeks, you have to approach the appellate court.
Which is why, my lords, the order of 23/9/2019 becomes relevant. It says we make clear that as the appellant has sought repeated adjournments, even if the appeal is not entertained, time for preferring an appeal granted by the learned single judge will not be extended. This order has not been disturbed. Thereafter, my lord, there appears to be some cloud of a stay which, in my respectful submission, has never been granted. That's my limitation.
We have it on Monday, my lord, if I make a request. Monday or Tuesday, any day convenient to this court.
Yes, see next week. Next week, this week. You can give before that also. 21, 24, 23. This is tax. This is direct tax. This is indirect.
Indirect tax.
Give it 28th. What? 28.
28/10. 28/10.
My lords, I apologize. Serial number 1 to 3 and 14, my lords. MSA 42 to 45. The other side is
So
present.
Shetty, they wanted a change of date. 25, na?
25/11, my lords.
Have it on it. Just change the date. 1 minute. Just 1 minute. Just 1 minute. We will have it on, not on 25. We'll have other than Monday. With 25, we have direct the tax matters. So any other date?
26 is also fine, my lords.
26th. 26th.
Grateful, my lords.
26/11. Next.
20, 25, 26, Sajjan, 27, Srimati Nidhishri, 27.
For the appellant. Hearing for the appellant. Other side had short time.
Yes. Just pass over.
28, Mr. Shashidhar, 28,
Pass over.
29,
Yes, ma'am.
Lords, I seek for a small accommodation.
Pass over. We'll see that. We will see that. If matter doesn't reach, it's good for you. It will get adjourned. If it reaches, then we will see. Next.
30. Okay, for the appellant.
Yes, ma'am.
Here, land was acquired under National Highways Act, was awarded by SLO. And
How much has been increased, the compensation?
it is 3 times increased by the arbitrator, because under NHA there is a provision
In
for.
terms of that section 3GH, that's right?
Yes, yes.
And 34 dismissed.
Yes, Milord, I mean, just there are some more facts here. What happened that respondent number 1 is not the original owner. Original owner never approached and took compensation.
What did you do with the compensation?
So it was with SLO because there was no dispute. There was no dispute, but
okay.
no one came to collect. So after 8 years, respondent number 1 approached and took the compensation based on the power of attorney. He was the purchaser of unacquired extent.
No. Took the compensation means from whom?
Collected from SLO.
He disbursed it.
He disbursed it based on power of attorney. He had a power of attorney to collect the compensation. So he collected acquired extent. So he, after 8 years, he collected the compensation, unacquired extent only. But he had a power of attorney.
For the acquired also.
For acquired portion to collect the compensation. So and then he filed the approach arbitrator for enhancement in compensation. Arbitrator passed award and enhanced the compensation from rupees 1926. Respondent approached Honorable High Court of, unacquired extent, purchaser of unacquired extent. So he approached arbitrator. Arbitrator passed award. Then he approached High Court that I'm not satisfied with this and I should get under right to fair. High Court said it's respondent number 1 approached district court. District court set aside the
Could not get who is the respondent. Respondent number
1 was the purchaser, that's purchaser of unacquired extent.
The power.
1 is power of attorney holder. Respondent number 2 is arbitrator, that is deputy commissioner, and respondent number 3 is SLO. So then alternative remedies there. So he withdrew and approached the arbitral award. And since based on the Honorable Supreme Court judgment that can't remand, so did not remand and specifically said we have no power.
Remanded. One set aside.
Set aside. And specifically court mentioned that I can't remand. So they had asked for remand. Court.
But did they invoke the arbitration clause again?
Yes. Yes.
That's the law.
Yes. So they invoked the arbitration again. But in my response submission, once award is set aside, first award is set aside, first award is gone. And then it's a fresh arbitration. They say no. Because first arbitral award you didn't challenge, you can't raise, you have all the right to raise issues.
Notice has been issued. Are represented? Who appears for 1?
There was a caveator also, one Mr. Pradeep C.
He appears. Generally, he appears, Mr. Pradeep.
Where is the order sheets?
Last they took the time.
We just pass over.
Please, Your Lordship, please. So my main grievance is about limitation, my lord, which I will just submit when he is here.
The limitation on the fresh
Before-
invocation. on the
No,
fresh-
no, even first. Before arbitrator, so that we raise,
Is your own case, the first one has gone, it has been set aside,
yes, yes.
So-
So
so-
before second also we raised that.
right? If you are raising a limitation on the first, we then it use or continues.
No, my lord. So I am saying that is gone. And on second
Say
also,
that.
I'm
Saying,
yes, yes,
but otherwise it's all barred by time.
yes, yes.
Okay. Pass. Index all the passovers.
So matters, serial number 13.
1-3. Our service is complete to all the parties. My lords, lordship may kindly fix a date for a final disposal.
See, what has been urged is, yes, very Mr. Mittal, what was your submission?
Yes, my submission is that, my lord, the learned single judge allowed our writ petition, giving the liberty to the respondent, that is the Government of India and GST Council, to amend the notification. That notification has already been amended way back in 2022, 30th December. Now, to dragging upon this appeal will not survive any purpose because this was
Yes,
heard.
okay.
I have
Okay.
appeared 4 times.
We have heard you, Mr. Mittal, just 1 minute. Yes,
My
now,
lord, this is with respect to the, my lord, the previous period prior to the, my lord, issuing, modifying the notification.
see the learned single judge order.
Yes.
Let's see the impugned order. Huh?
Yes, is engaged. May I have? So that's the reason only, my lord, I'm seeking
See,
accommodation.
we will see it. Let's see now. Let's see what is the submission.
Yes,
Item 14,
this is on annuity payments.
13.
13, my
Yes.
lord, item 13.
Yes, yes.
742, appeal number 742.
Huh. Chincholi. So, in place of 17,621, Mr. Mittal, according to you, they have come up with the fresh circulars.
Notifications, my lord. thus-
Notification.
Very well. Notification,
happened?
that's under the act.
Yes.
Yes.
Now,
There was
now
just
what
one
is
line.
the, 1 minute, what is the effect of the fresh notifications?
Yes, that exemption has now been withdrawn. Earlier, there was an exemption, which was I was enjoying right from the very beginning. In the meantime, a circular was issued, and the court has held that the trial court, the writ court, that the circular cannot override the notification. If the government want, then they can amend the notifications. And accordingly, notification has now been amended on 30th December 2022. That exemption serial number 23A entry has been now deleted.
See paragraph 14 of the impugned order.
Please.
Para 13.
Yes.
Read para 13.
It is a settled proposition of law that a circular which clarifies the notification cannot have the effect of overruling the notification. In the instant case, what has to be considered is whether the impugned circular is in violation of notification number so and so, or clarifies the said notifications. As stated above, the deliberation of GST Council in its meeting held on so and so and the notifications issued pursuant thereto clearly exempts the entire annuity being paid to the petitioners towards construction and maintenance of roads. It cannot be construed to have not exempted the annuity towards construction of roads. The impugned circular has the effect of overriding the notifications bearing number so and so and has to be held as bad in law. Nothing prevents respondent number 1 from imposing GST on consideration paid to concessionaries like the petitioners on payment received by them by way of annuity, but that has to be done in a manner known to law. In the instant case, the respondent number 1 has issued the notifications.
You have instructions that new notifications have been issued now
Yes, ma'am.
on the same subject?
Yes, ma'am.
The subject which was earlier governed by circulars, now they have brought the notification.
No, well, earlier also there was a notification. Earlier also, there was a notification granting an exemption. That is their claim.
That's right. It
Now the
appears so, that was not accepted by the learned single judge.
No, it's not. Earlier, my lord, they say there was a notification granting an exemption. That exemption includes this also. That is the contention of the petitioners. Now the circulars issued clarifying the, my lord, the notification saying that this doesn't include in the exemption.
So what is being urged is circulars are not what is contemplated under the notification.
See, that's what the learned single judge held, that circular is something, my lord, which is contrary to the notification.
That's right. So if that be so, have you brought fresh notifications on the subject which were governed by the circulars?
Yes, my lord. The earlier notification, which granted an exemption, is withdrawn completely now.
Now you have brought out everything afresh.
Afresh.
What is the effect thereof?
My lord,
what is the effect thereof? Now those notifications would govern for future or back also.
no, it is only future, prospective.
If that is so, what is the effect on this?
So, my lord, there was a defect in the earlier notification
Obviously.
circulars.
So that defect of circular was cured by fresh notifications. Circular could not have been acted upon. The previous notification doesn't govern the issue. What is it?
That is inference can be drawn. That inference can be drawn, my lord.
No, we want to put it to you.
Yes.
What is the, so.
No, the effect is that, my lord, the notification has some lacuna. Circulars clarifying it also has some this thing. So they have done it afresh.
You relied upon circular. They say circular can't be contrary to notification.
That's
the
precise point, my lord.
What do you want now?
Now, my lord, I just 10 days time, my lord, ASG has been briefed. This is the only, my lord, issue. My lord will conclude.
But surely you will brief ASG what we have observed in the sense.
Yes.
And what are your instructions from the department?
Please.
Just say this, just say that Mr. Mittal appearing for the appellant, for the respondent.
1 and 2.
1 and 2 would submit that pursuant to the impugned order, the respondents have brought out a fresh notifications. Full stop. The learned counsel for the appellant states that he need to take instructions on this submission made by the counsel for the respondent and request for a 10 days adjournment. At his request, re-notify him. Yes.
Four 11.
See.
411.
Lordship, Mr.
My
Mittal.
lordship, can you say, my lord, service is complete. So, my lord can have.
There is an issue of service.
Yes, no, that's the purpose for which it is posted. All the parties are served, I believe.
Respondent number 4.
They're all there on online.
13. You appear for all?
Mr. Manu K is online.
My lord, sir, insofar as 744 is concerned, my lord, the second writ appeal, I have not been given the copy of the writ appeal, my lord. They may be directed to serve a copy.
Yes, I'll
just 1 minute. Let's plot. Mr. Mittal, you appear for whom?
1 and 2, my lord, because the 1 and 2 only affected party respondent, because I am the taxpayers. Others are.
Who appears for 3? NHAI. Her name, just record her name. Karnataka Road Development Corporation.
I am appearing for the fourth respondent in this manner.
Ministry of Road and Transport, Government of India. Who appears for Government of Karnataka? You appear. Ministry, then you can also appear for. You represent Union of India.
No, my lord, I represent only the department, one wing of the. My lord, that my lord, I will serve on the central government standing council.
No, yeah, you know why, ma'am? You need to appear.
Yes.
Because this Ministry of Road and Transport is because of NHAI.
Yes.
Because for NHAI. 4 and 5, just record her submission.
3 and.
Well, no, 3 and 5, sorry, my mistake. Now, in the second one, 13.1.
Mr. Mittal appears only in the first one, that is 742.
Very well. We'll record, so he doesn't appear in this, the other.
He's not appearing in the.
Now,
Mr.
let's see the
Raghuraman.
second one. Who appears for one?
I am for respondent number 1.
You for 1?
744.
744.
No, this is Department of Revenue.
My lord.
No, sorry.
Writ appeal,
Writ appeal.
Yes.
See, Union Department of Revenue is an appellant.
Yes, I am for the respondent number 1, your lord.
I am representing.
Fine. Yeah, 1 Inca, 2 is ma'am, and and 3 is Karnataka
2 and
Road
4.
Development Corporation, you appear.
I appear for the Karnataka Road Development Corporation.
Ministry of Transport, you appear, ma'am.
Yes.
So
Lord,
2 and
since-
3, unka, 4, 5, Government of Karnataka is this. To stop in view of the fact that all the respondents are represented in these appeals, notice, if any, notice to be, if any, to be issued to the respondents is dispensed with.
Next.
Okay.
Yes.
My lords, for the third respondent, my lord, in the second,
Let a copy of the appeal be given to the council appearing for
Respondent number 3.
respondent number 3, Karnataka Road Development Corporation.
Yes.
In
Yes,
both the
my lord.
appeals. In both the appeals.
Grateful, my lord.
Your lordships have indicated a date,
Pardon?
410.
410, 411.
4 lines.
Great.
Serial number 15, Timothy Swapna Nair. 15.
Come.
15.
15, there is no appearance. There is no appearance for the appellant even on the second call. What was the report, ma'am, in this? In the report? Full stop. This is an application filed by the appellant. IA 1 of 23 has been filed by the appellant for recalling of order dated 7/8/23. In view of the fact that there is no appearance for the appellant even on the second call. Comma. The appeal application is dismissed for non-prosecution.
Serial number 18.
Really grant a week's time allowed. There is some inconvenience. Senior could not come.
Let's see what is the matter. 18.
Senior wants to make his submissions today. Any date may be given.
Let's see. 18. Yes. Was any date given in this?
No, sorry.
Or usual course? But who is the senior?
PN Rajeshwar.
But he was not there on the last date. Same request was made. Will not allow it.
My lord,
We will
his
not allow
relative,
adjournment.
his relative has expired, my lord. That's the reason he could not come today, my lord. Kindly grant a week's time, my lord.
Adjournment is sought by the council on behalf of the council for the appellant on the ground that there is a bereavement in his family. Re-notify, just give next to next week.
Grateful, my lord.
30th 10.
No further adjournment.
Sir, 30th October.
Much obliged.
No 30th October, just give 1-2 days before. 29th.
29, sir. 29/10. Serial number 20. Serial number 20, Sri Ravindra. 20.
Pass over.
21.
My lord, in this matter, my lords, I appear for the appellant. I apologize, my lord, for not being able to appear in person today. My lord, this is a section 37 appeal. My lord, and our grievance, my lord, is that none of the grounds that have been urged by us in our section 34 application have really been considered by the court below. My lord, this is a case where, my lords, the arbitration arose out of a joint development agreement where, my lords, we had agreed to develop, my lords, a property of around 10 acres. And the contractual consideration, my lords, an advance was paid to the landowners, and the remaining sum was to be paid when the within 2 years of the approval being obtained. Now, what happened in this case, my lord, is that the owners of the land themselves dragged their feet. They did not cooperate, my lords, and we cannot get a plan sanction. We cannot get many of these documents, my lords, without the cooperation of the respondents. They were then engaging with other purchasers, my lords, because they thought they would get a higher price. It is in those circumstances that the arbitration was commenced. And the arbitration, my lords, was commenced by us for seeking an order of specific performance. My lord, the arbitrator, my lord, has rejected our claims for specific performance, my lords, on 2 or 3 main grounds. And my lords, those grounds are grounds which are really not pleaded by any of the parties. And my lords, is contrary to the evidence on record. And that's the reason why the section 34 was filed. My lords, the first ground on which the arbitrator denies us our claim of specific performance is by saying that time was of the essence of the contract. Now, my lord, 3 aspects about this. 1, the contract does not specify that time is of the essence. Second, neither of the parties, my lords, contended before the arbitral tribunal that time is of the essence. So therefore, my lords, this is a finding that is dehors a pleading. The third aspect, my lords, we had also relied upon a judgment of the Supreme Court to say that in transactions involving immovable property, time is generally not considered to be of the essence. So, my lords, none of this has been considered by the arbitrator. The second aspect, my lord, on which the arbitrator denies us relief is by saying that we did not prove our financial capability of performing the transaction. And what he says, my lord, is that the amount that had to be paid to the respondents was a sum of around 18 crores. Our financial capability is 28 crores based on the evidence that is placed before him. And he says 28 crores is less than 18 crores. So therefore, it's clearly a mathematical error. It's a contradiction that is apparent on the face of the award itself. And he rejects us, the claim of specific performance on this basis. This was challenged before the trial court. The trial court does not engage with any of the grounds, and that's the reason, the section 37 appeal has been filed.
What does he say, the 34 court, on
Yes,
this
ma'am.
18 and 28?
Well, he doesn't refer to it at all. There is no discussion of that aspect at all.
Let's see the finding there.
Well, let's kindly see, my lords. The finding of the arbitrator, my lords, is the arbitral award is annexure B. And the findings on this aspect of 28 and 18 crores is paragraphs 29 to 32 of the arbitral award. 29, my lord, is at page 80. And at page 81, my lord, around the middle of the page, he says, therefore, I'm so sorry, my lords have page 81, my lord. Paragraph 29, my lords, and I'm relying upon the last portion of paragraph 29 and the first part of paragraph 30. It's at page 81, my lord. With your lordship's permission, could I just read that portion, my lord?
Where is that finding what you are saying?
Well, it's paragraph 29, my lords, the last portion. I'll just read it out, my lord, of the arbitral award. This is at page 81. At paragraph 29, my lords, the last sentence, just above paragraph 30, all put together, the total amount which is available with PW8 and his wife would be 28.82 crores. This is our financial ability, which according to the arbitrator. In the case on hand, it is to be noticed as evidenced by Exhibit P3, the total amount which is payable to the respondents is rupees 1.84 crores per acre. If calculated, its entirety would work out to rupees 18.4 crores. At 10 acres into 1.84 crores, therefore 18.4 crores. So, Malas, 10.84 crores is what we have to pay to them. Our financial ability, Malas, according to the arbitrator in the previous sentence, is 28.82 crores. Based on this, Manas, in paragraph 30, he says, having regard to the paucity of funds. There is no paucity of funds, Manas, because 28 crores is more than 18.4 crores.
The notice has been issued?
No, sir.
Not issued?
No, no.
Who is the caveator? It shows the file physical. Notice was not issued to 1 and 2.
I don't think notice has been issued, but there was a caveat, my lords. But there's no difficulty, my lords. I will take out notice once again.
Pardon?
Well, I think they were on caveat, my lords.
It appears R3 was on caveat. Huh?
Is the contesting respondent? R3?
They haven't appeared in the previous respondents 1 and 2,
No, you want to know, have they been served?
I will take out notice, my lords. I will also serve the counsel who appeared, my lords, for them in the trial court.
It's not been issued. Who was the caveator?
KC Ravindra.
This is item number
21.
Just say this. Now, all the appellants 1 and 2 were also before the arbitrator.
Yes, my lords. Claimants before the arbitrator.
They were all were defending it.
Yes, my lords.
Just say this. We issue notice to respondent 1 and 2. We also find that the respondent number 3 is the respondent number 3, the caveator, is being represented by Mr. KC Ravindra Babu, advocate. He is not present today. Disturb, re-notify on the date fixed when service on the respondent number 1 shall be effected. Re-notify.
10-12.
My lords, I'm also requesting a stay, my lords, because what the trial
You
court
serve
has
them,
done.
please. You serve them first.
I will do that, my lords, I will do that. Deeply obliged, my lord.
Serial number 22. Government advocate.
The applicant is a state member. The only question that arises is when there are two distinct provisions, one for a pre-appeal deposit and the other for a surety for release of the detained goods and the vehicle, whether one can act as a substitute for the other. Before that, my lord, there is a delay of 189 days.
How are you aggrieved by this order?
My lords, the vehicle and the goods have been released upon furnishing of a bank guarantee, which the respondent in the appeal voluntarily provided. Then he invokes his appeal, right to appeal under 107 of the Act. Under 107 of the Act, he is required to pay a 25% pre-deposit. The learned single judge says that if the deposit is made, then the bank guarantee securing the release of the goods, which is under 129, has to be released. My lords, I have therefore no security for the value of the goods which
come to the order.
My lords. Order starts on page 16, my lords.
So just see that it is submitted by.
It is submitted by she so-and-so, learned counsel for the petitioner, and she so-and-so learned additional government advocate, that during pendency of the petition, an order as contemplated under 129(3) of the CGST Act is issued on 17/3/2022. And even the subject conveyance is released as against the surety bond and the bank guarantee that is furnished by the petitioner.
So you yourself has released it?
Upon him furnishing
the bank guarantee?
My lords. The petitioner has offered surety and furnished the bank guarantee for 100% of the penalty. The petitioner's remedy as against such order is 107 of the CGST Act, and the petitioner can avail such remedy upon deposit of 25% of the penalty as contemplated under the proviso to section 107 of the CGST Act. They also submitted in the light of the subsequent events, the petition would be disposed of. If the petitioner has obtained release of the vehicle against furnishing surety and bank guarantee, which is 100% of the penalty, that is 100% of the penalty, and there is an order as contemplated under 129(3) of the Act, the petitioner, if aggrieved, must avail the permitted remedy under 107 of the CGST Act. If the requirement in law that the petitioner must deposit only 25% of the penalty to avail such remedy, petitioner cannot be fastened with the responsibility to pay 100%. Therefore, writ petition stands disposed of with liberty to the petitioner to avail remedy under 107. Upon deposit of 25% of penalty, the petitioner shall be entitled to return of surety bond and bank guarantee furnished. Upon filing the appeal with the deposit as aforesaid, files with the first respondent, details of the appeal and deposit made, first respondent shall within 10 working days. My lords, my only submission is, if your lordships are pleased to look at 129 of the GST Act. (129) starts with a non-obstante clause, my lord. Notwithstanding anything contained in the Act, where any person transports any goods or stores any vehicles while they are in transit in contravention of the provisions of the Act or the rules made thereunder, all such goods and conveyance used as a means for transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released on payment of penalty equal to 200% of the tax, and in case of exempted goods, on payment of amount of 2% of the value of goods or 25,000 rupees so and so. B, on payment of penalty equal to 50% of the goods or 200%, whichever is higher in case of exempted
goods on payment.
Which is the remedy for appeal? Which is the
107.
One,
The remedy is 107.
against this order
Yes,
of 129(3), he has a remedy of appeal
yes,
under 107.
yes,
Now 107 contemplates
25%.
pre-deposit of 25%.
Yes.
That's what can be. That's the provision of law,
Please, my lords, but
but
so
you have to correct it.
maybe so, my lords. But 129, which starts with a non-obstante clause, cannot by judicial pronouncement, my lords, be overruled.
See, 129 is the substantive clause which determines about seizure and release of goods separately.
Yes,
It's a case of seizure.
yes,
Penalty shall follow.
yes,
That's one aspect.
yes,
Against penalty, he has a remedy under 107.
yes.
107 says it will be heard provided you deposit 25%.
My lords.
So you should correct the provision.
My lords, that is in the realm of the legislature, my lord.
You don't know. So that's true. Very well. Let's take that point, your submission. It's in the realm of legislation. In the legislature, in its wisdom, has said it should be this position.
The legislature has said both, my lord. The legislature has said both.
What? Where? Does 107 say so?
107 mandates a pre-deposit.
Of 25%?
My lords.
That's it.
129, my lords. Your lordships may kindly see the non-obstante.
Right.
Yes.
129 is substantive provision which deals with seizure and forfeiture or imposition of penalty. That has been acted upon by you.
Under 129(1), the order that is passed, against which he is in appeal, is under 129(3). My submission, my lord, is that the non-obstante in 129(1).
With the non-obstante, it will not help you.
My lord, it says notwithstanding anything else in the cut.
To the extent of 129.
Precisely, my lord.
To the extent of?
Yes.
129.
Yes.
Now, is 129 must be read with 107? No. That's the reason we are saying, look here.
If 129 is not read with 107, then 129 is independent. There's nothing over.
Right. What is 129? Seizure, forfeiture, penalty.
Yes.
Independent.
Yes.
It's not an appellate provision.
Not at all.
What is the appellate provision? Is 107.
Yes.
To the extent anything contrary or at variance is there to 129 in the Act, 129 will prevail. That's the intent.
Precisely, my lords. Therefore, 100% of deposit has to prevail.
100% as a penalty.
100.
This 25% is not as a penalty.
That's a condition of the appeal. Now, 129 says that that is the condition on which I have to release his vehicle. So therefore, my lords, he voluntarily submits the bank guarantee and takes the vehicle back. So I have security for the value of the penalty because I've released the goods. Had he not furnished it, I would not have given him his vehicle.
Then tell us one.
Yes.
If 129 says very well, order pass, you deposit 129, I'll release the vehicle.
The order, my lords, is in 100, please, my lord, the detention order. The penalty order is 129(3).
Yes.
Yes.
Then why the legislature has included a pre-deposit provision in 107?
Because, my lords, 107 is any order under the Act. It is not specific to 129.
Includes an order under 129?
Includes an order.
It should have said except 129.
That except 129 is in 129. That's my submission. 129, since it starts with a non-obstante, cannot be subservient to 107. Or in any event cannot be tied to 107.
A corresponding clarification with 129. That's the reason we are saying 129 doesn't talk of, it's not an appellate power. It's not an appellate remedy. 129 is this.
It is security, my lord. He takes the goods back.
So to the extent 129 you will interpret to mean any stipulation under the Act which corresponds to seizure, penalty or forfeiture or whatever is that, it would be 129 which will prevail. But 107 is an appellate remedy. Appellate remedy means which is independent of 129 and cannot be read, both read together, or you can't read in 107 something what is contemplated under 109 unless and until you have any judgment on this, please show us.
Now, let me say this. Under 129, I seize the goods. He seeks the release after the detention by furnishing a bank guarantee. An order of penalty, my lords, is passed under 129(3). He chooses not to appeal it. He chooses not to appeal it. The security for payment of penalty
Tell us one thing. Is there any difficulty for you? You have filed the appeal? Have they entertained the appeal?
10% other than penalty proceedings. For the penalty proceeding, 25%. There is a difference.
Pardon?
If the penalty, the final appeal under section 107, against the penalty check for note, 25% free deposit. Then penalty note, then only 10%.
Now, tell us one thing.
But I have paid the
Have they entertained the appeal? Are they hearing the appeal? Have they released the bank guarantee and the vehicle?
Yes, ma'am. I've complied with the order.
See the impugned order.
I've complied.
Before the appeal was filed.
I've complied with the order.
You have complied with the order?
Yes. My instructions have been complied with the order. Unless, well, learned friend says to the contrary.
Then how? Then why this appeal?
On the principle of law, my lords, if your lordships are pleased to hold that the question is left open, I do not have a difficulty. I'm not in a particular case with respect to one truck. I'm not, but respectfully, my lord, what happens is that the interplay between 129 and 107, I would, my respectful submission that your lordships may either hear or leave the question of law open. Because if the judgment of the learned single judge holds field, however good intention it is, I am in difficulty.
Your vehicle has been released? Just asking.
Your vehicle has been released.
Appeal has been dismissed by the appellate authority. Against the appeal, I have also filed a request before this all.
We will say so. Question of law will leave.
Yeah, I'd be obliged.
We will leave the question of law open. We will record that. Where have you framed any question of law here?
My lord's first appeal from a writ petition, there's no requirement. But in my grounds,
this is the only submission?
Non-obstante of 129 is the only submission.
Very well. Just state this. The challenge in this petition, in this appeal, is to an order dated 31st March 2022. In how many appeals are there?
Single appeal.
One appeal. In writ petition number, which is the page of that impugned order?
My lords, impugned order starts at 16. The relevant portion starts at 18, my lords.
In writ petition number 5275, yes, ma'am. 5275 of 2022. Delay, okay, we'll condone it. We'll condone the delay. Delay also pass in order for the reasons stated in the affidavit in support of the application. There is a delay?
189 days.
Condone. Then come to the main order, 25th March in 5275 2022, whereby the learned single judge has disposed of the petition by stating in last paragraph, this is page 19, running page 19 and 20, as under we have been informed by the counsel appearing for the respondent that the respondent has filed an appeal which has been dismissed and against which a writ petition has been filed before this court, which is pending consideration before the learned single judge of this court. The learned counsel for the appellant would submit that the reason for filing the appeal is the present appeal is for the reason that the order dated 129(3), which was impugned before the appellate authority, 129(3) of the CGST Act, the impugned order before the appellate authority stipulates imposition of penalty, relates to detention, seizure, and release of goods and conveyances in transit. Whereas the learned single judge by the and the remedy against an order passed under 129 is to file an appeal under 107, which though contemplate pre-deposit of 25% of the penalty, but in view of section 129, but as section 129 is a non-obstante clause, the condition of pre-deposit to the extent of 25% shall not be applicable when an order under 129 is passed.
My lord, shall not substitute the requirement for furnishing security to the extent of 100%. To the extent of
shall not substitute the deposit of 100% of penalty imposed under section 129.
For release of goods, man.
For the release of the goods.
My lord.
For the release of the goods.
My lords.
We have been full stop. No release of the goods. He states that during the appellate proceedings you have released the vehicle.
Yes, once the
he states that after the filing of the appeal by the respondent, on deposit of 25% of the penalty, the vehicle as well as the bank guarantees have been released.
Yes.
In favor of the respondent.
Yes.
Full stop. He states that since an important issue has been raised on the interpretation of section 107 section 129 qua 107 of the CGST Act, which will have a effect in which will affect the future cases, the appeal having been filed, in the facts of this case, that the appeal filed by the respondent before the appellate authority has been availed and dismissed by the appellate authority, and a writ petition is pending. Moreover, on the deposit of 25%, the bank guarantee and the vehicle have been released, as the interpretation of 107 and 129 arises in this appeal, we leave the question of law open to be determined in any other case.
My lords.
In any other case, with the above observation, the appeal is disposed of.
My lords, I'm grateful, my lords.
Okay.
Deeply obliged.
We have left the question open. That's why you will work it out, so that at least this should not come against them in future.
My lords, I'm deeply obliged.
We'll just come in 5 minutes.
పెట్టుకొని తీసుకుందాం అనిపిస్తుంది.
Yes.
My lords, may I make one submission with regard to the matter which lordships have reserved for judgment, my lord, that customs appeal. I have, my lord, filing a memo for my lord, just for my lord's consideration for framing additional substantial questions of law, my lord, sir.
You say it in your submission, we will see. We have asked the other counsel also to respond.
I have served the, my lord, a copy on them.
These are your submissions?
My lord, there's only a memo for, my lord, substantial question of law.
No memo, you file your submissions and say whatever you want to say.
No, my lord, my lords have heard me without there being a substantial question of law. My lords are empowered to frame a substantial question.
Then we have asked her to submit.
That's
understanding. We have reserved it.
Yes.
You will file your submissions.
Yes.
That's the reason we have asked her to give the supplementary the submissions.
Please.
We will say so, then we will consider it, then proceed.
Please, my lord. But this has to be, my lord, for my lords, this thing.
I know we will still consider it. Why don't you say in your submissions?
Please, my lord, I will.
Getting the point?
Yes, yes, yes.
Your duty is to convey to the court. You will convey it through your submissions. They will respond to that question of law in their supplementary submissions.
Yes, yes, my lord.
We will consider it.
Please,
It's as good as we have heard both the parties on that.
Yes, yes.
Do that.
No, my lord.
We don't want, we want your submissions to be there along with this supplementary question.
This substantial question of law. Yes, yes, I will make it, my lord.
So that we have composite, we will look into it, then we will consider it.
Please, please.
We will say so what, we will see what is the effect of that substantial question of law, whether it could have been urged there or now it is being urged for the first time. We will see it.
It could have been urged, my lord, not urged, but since it's a pure substantial question of law.
Say everything in support of that question of law.
Yes.
It's a pure question, legal question. It can still be considered, no disputed facts.
Yes.
Say so.
Not this.
Yes, call.
27, Srimati Nidhishri.
The respondent in this case. Yes. My lords, I paid time.
We will not adjourn this.
My lords.
We are not adjourning it. We are adjourning all matter. We will be just doing nothing.
The senior is out of country, my lord. He has gone abroad.
You will argue.
He will be coming on 24th, my lord. Any date after 24th may be given so that we'll argue the matter.
Was there any date given in this?
No.
Huh?
No.
We will give the dates next week. Which is the matter, ma'am? Adjournment is sought on the ground that the arguing counsel is out of country. Adjourn to.
November
20th.
Serial number 28. To Shashidhar.
Pass over.
29.
My lord, I appear for the appellant, my lord. I am sorry that I am, my lord, this appeal arises as against an order rejecting the application under section 34. My lord, I am not fully ready with the case because there are certain technical words that are used which I could not understand. I will give my submissions, preliminary submissions.
Just show us the last order. This is the last order?
Yes.
This is the last order?
Yes, sir.
What are the technical words?
Some GK RAM, various micro CD cards and so on and so forth.
See, we are also similarly placed like you. We also don't understand it. We will try to understand together.
My lord, I need instruction from my client to speak about it. But otherwise, I will give the outline of the case if your lordship permits me.
Not outline, we want it. Who is representing the other side?
Sharath Gowda. GB Sharath Gowda.
In
Yes,
fact,
where is the counsel?
my lord, we had requested Mr. Sharath Gowda that we would be moving for adjournment. he said he has no objection for the matter to be adjourned. We have informed him, my lord, I am not able to get ready totally, my lord.
Okay, the request of the counsel for the appellant. See, this we are only adjourning for the reason that there was no date given. And you must have come to know about the matter yesterday, last evening, when the list was circulated.
Yes, my lord. Yes, my
That's
lord.
the reason we know that. We are now giving a date. You have a date. So we
No,
need to.
by that time, I will certainly get ready. In fact, I am
Re-notify.
1911.
much obliged, my lord.
Serial number
We'll go, we will see when the date is there, then we will hear it. We
Yes,
appreciate your position. Okay.
much
Next.
obliged.
serial number 30.
You file you file submission. Next.
30.
Yes, ma'am.
Your lordship asked me to file something, my lord.
No need, I don't think so. We have, all the judgments have been referred by the trial court
Yes, my lord.
on 34, 37, everything. We'll see that.
Much obliged.
Yes, ma'am. Who is representing the respondent?
Pradeep Yadav, Prakash Angadi.
Is anyone representing the respondent?
Yes, sir. For R1, Pradeep Yadav. R3, Prakash Angadi.
Ma'am, all have been served. All have been.
Seem to have filed a KV.
Where is that plea or where is that finding based on the first award? Where is the plea that once that first award has been set aside, that award cannot be looked into, or no benefit shall inure to the respondents based on that first award? What you have argued in the morning. That's on the first award.
Second number was the same thing. Because that was filed subsequent. So when we take date from the passing of award, it was in 2011. And this was filed in 2018 first place.
What is the finding of the arbitrator on the first award, so second award on limitation? No. No, at least surely for me, I require translation. To understand what is your case, let's see.
Second paragraph, respondent.
Now tell us one thing. This English portion is the translation of the earlier portion.
Even our type, some portion in Kannada and some portion in English. It is arbitral of as it is.
The respondent in his objection contended about passed by the while the petition. During the August after lapse of 7 years from the date.
The respondent number one, after award on number 27, it is 28, what is called the word, this is the completion at the date of also, it is seen from the record. The petitioner approached the obtaining the number of 100,000 value. I just hold there for a moment. What will happen? They took the for the first time before the arbitrator second round. What is the contention? That original owner had required application in January 2020. That is what they have contended. Before the court, and so they contend, but it came arbitral for the first time. It was not mentioned anywhere. So when it was taken, before, we said from when January 2010 came, because, but if you make, if you are not to look at the number, its number is also of 2018-19. Even this article is saying it was filed in 2018 August. So from where this January 2010? They say that it was filed in, filed by the original owner. That was one case filed by original owner, then second case filed by the owner, and that was taken. Then we, at our request, Honorable Court, District Court, sought for the record. From the, so record should be available in the news. Then we can see that there is a inward register at the Deputy Commissioner's office, Arbitrator's office, saying that 1, 2, 3, 4, 5, and 8, then at one page, it will come by showing them. And just entry, you can see that it is added here. And it is entry. Everyone is 143, 4400, and then it is 145. So that was our contention. That this is only added later to bring this limitation to the basis. So arbitrator helped them to see that it is at the same it was filed in January 2010. Then I so then I will show it not the record.
Show us.
Yes. LC. From that arbitrator. Do you have other papers from arbitrator, Deputy Commissioner's office? Only that is. These are also. Huh? Lord, I don't find it here. It's all like a court record, but not from arbitrators.
But ma'am, tell us one thing, why
Yes.
don't you file translation of this?
Sorry,
Translation.
I will file it.
So you have to file it. We can't because
I will definitely file it.
suppose something turns out on that Kannada portion,
I will definitely.
the counsel for the appellant shall file the English translation of all the Kannada documents. Now, ma'am, who are, everyone has been served?
Yes, representatives.
Now, one is this, who is one appearing for one? Has it been served? He's a caveator. But was he present when notice was issued? You represent 2 and 3 now?
Not, I represent 2. 3 is the land acquisition officer.
One Mr. Prakash Angadi is appearing.
You are. Is he represented? Three.
He's represented. Represented.
They were present. All three were present. Okay. So all three were present. Just check up. All three are present. You were there. One is caveator. Three is
Formal party.
so you are the beneficiary. So the anything enhanced would come from you. Then just show us. Three. He's on record. No? He's there. There is no representation. 2 Pradeep Yadav for 1. And ADA is present. Okay. Within how much time you will file it? Well, you will file it within 1 week. You don't know how many documents are there. No, you have to check others also. All Kannada documents. Yeah, file it in after 3 weeks, within 3 weeks. You file it within, just give it somewhere.
13/11, madam.
13/11, man.
13th of November.
And that's all, anything else? Huh? Call them.
Number 20.
No, was it brought before the 34 court? No, why we? Because to my recollection, if you see the, it was returned, I suppose. No, I think the learned judge makes some observation on that. This. Say within 3 weeks. Who will get the award? It would be before the arbitrator. Just check up that. See, TCR kept below. It's only is the arbiter. Whether the record has been sent back. Just say this, that let the arbitral record be requisitioned from the respondent number. So you would be representing him. Then we will put on you. The learner counsel appearing for the respondent number 2 shall place before the court, shall produce the relevant arbitral record. You produce.
That is my role, because I don't defend the award.
That's right.
This is my role to assist your lordships.
We'll see. Chile. Thank you. Just call 20.
For 20.
Was anyone present on the first call?
So nobody was there, nothing also.
There was no date, no, ma'am. There is no date, no, on the last date. None for the parties in the interest of justice re-notify.
12/11. Serial number 28. 28.
Why? Who is trying to settle? So? Just say at the request of counsel for the appellant, re-notify.
14/11.
That's all, ma'am.